We have one more example of a modification, then we move on to other things. And you're all saying, thank goodness. Here's a contract that shows the utter brilliance of a particular department. I don't know which one it was. There's some initials up there, but I don't know what they mean. But this agency had a contract for a vendor to operate a call center to answer phone calls for state agencies, phone calls made to state agencies. The solicitation identified 5 specific agencies that initially would use the call center and types of calls received by these agencies. One of them was DHMH. One of them was DHR. One of them was DVM for the state telephone operator, the central number. Because these existing call situations had very detailed usage experience in terms of the average duration of calls, the specific scripts for most questions, etc., a fixed price was requested for each type of call to each of these agencies. So the vendors were told, here's the average duration for a call to DHR, and it's typically on this subject matter, and we gave them attachments. Here's the calls to DHMH, here's the average duration, the type, etc. And they gave a fixed price per call. And this was a change, because before that it had been simply on a charge per minute. So every minute the vendor had one of their attendants on the telephone, they were getting paid per minute. And the minutes were being racked up, and there was some thinking that perhaps the vendor was not being overly anxious to end calls, and so they were just trying to elongate the calls and jack up the minutes of charge. And so the thinking at that time was that because we could be very specific about these 5 agencies and the type of calls, why don't we go, instead of having the usual call per minute, to just make it a fixed price per call. So there was no incentive whatsoever for the vendor to be on the phone longer than necessary. Hopefully they would not be on too short to not take care of the call, but they wouldn't try and stretch it out. So we thought this was a good deal, change it to fixed price, and all was right with the world. But then we had this other thing. Aside from detailing the intended usage of the call center by the 5 agencies, it was stated in the RFP that any state agency could elect to have the vendor assume its call center duties during the term of the contract. So 5 agencies would be definitely using it from the very beginning. These 5 agencies, fixed price, but any other state agency that wants to have the vendor take their phone calls for any call of that the agency would receive, this vendor would do it and would handle it under a master contract. And that's what this was. It was a master contract for call center services. Anybody see any issues so far with what I've said? Something that we ourselves didn't see at the time? All right, let's move on. Yes?
I was going to say, by adding other state agencies, you like to get different types of phone calls.
Different type of phone calls?
Scripts for phone calls.
Might have been different duration, different types of script. So do you think fixed price for 5 specific agencies would apply to other agencies?
You'd have to do modifications.
Well, we anticipated other agencies could use it. But there's something we didn't anticipate. And it's like, duh. So about a year after the 5-year contract was implemented, several additional agencies expressed interest in having the contractor assume their call center functions. That's what a master contract is for, to be used. But the obvious was then discovered, as per your statement. Fixed prices per call for specific activities for 5 agencies did not provide a unit price that could be used by the contractor to charge any other agency that wanted to begin to use the contract. So we had a master contract available for use by all state agencies, but we only had prices for 5 agencies, and they weren't even unit prices. They were like a fixed price per call for those 5 agencies. And so when you wanted to expand it to other agencies, then we got into this back and forth between us at DBM, since we were the contract manager, and the vendor, because all right, well, we have these 5 fixed prices per call, so let's see which one of these 5 fixed prices we think would apply to agency A. And the vendor would say, well, no, I don't agree that I want to provide that service now that the agency has described it for that price. I don't think it's enough money. And so, no, I want the charge, and I think DHR was the one that was the longest. I think DHR averaged around 7 minutes per call. And the vendor would say, okay, I'll do the other agencies for the same fixed price as DHR is paying. But we knew the other agencies probably wouldn't be 7 minutes in duration, so we would be overpaying if we agreed to that. So the bottom line is, we came to the conclusion that we did not have a unit price that was extendable to other agencies to do the very purpose of this contract, to be extended to other agencies. Which is what this says. The master contract could not be used for any agency or purpose other than the 5 identified in the RFP, which is not a good solution when you're trying to do a master contract. This meant either that no other agency than the 5 original participants could use the contract, or that the contract had to be modified to incorporate a fixed per minute price for calls for any agency other than the original 5. So we either can't use it, or we have to do a modification for what its stated purpose was from the very beginning.
And what you were trying to get away from the per minute originally. That was the original intent.
That was the intent for the ones that we had knowledge about, but these other ones we don't.
Yeah, but with the other ones, you know you don't want to get a per minute rate because they'll just drag on the calls.
They can get back to that. So ultimately, it was decided to convert the fixed price per call for the 5 agencies into an approximate average rate per minute and use this per minute rate for usage by any agency other than the original 5, i.e., if you charged $7, and this is exaggerated, I'm just doing this for ease. All right, not $7, 70 cents. If the charge was a fixed 70 cents per call for DHR that runs 70 minutes, that's an average of 10 cents a minute. So once we did that for all 5 of them and got to an approximate rate per minute, we went to the vendor and asked them if they would agree to a modification to implement that per minute rate for any calls by any agency other than the 5 originally identified. And after when we first went to the vendor, they thought it was too low, so they wanted more money, and we went back and forth a while and finally agreed to a per minute rate that was acceptable both to us and to the vendor. And we went to the board with the modification because the presumption was that modification would end up with the vendor getting tens of thousands of dollars more business, over 50,000, so we went to the board and admitted in so many words that we just didn't think very well when we set up this original master contract. Whereas the contractor agreed to this approach, it wanted a higher per minute rate. I said that, which highlights the dilemma of negotiating modifications with vendors. When we go to them, they're the one that's in the driver's seat. And you either come up with what I want, or I don't agree. And if it's not something you can simply do a change order, where you need this mutual agreement, you're putting them in the position where they're in the dominant position. Let's see. When you're negotiating with a vendor, an in-place contractor, there is no specific competition, little incentive for the vendor to hold down modification rates, and often the state has little leverage in terms of using another vendor to provide services. We are captive to them. Not a good scenario.
Technically, if it wound up being 20 more agencies, you could have gone out and
We could have done new procurement.
competitive procurement, right?
And if it would have been that dynamic, we probably would have. But when it's 1 and 2, none of them is enough to warrant going out and doing a procurement by itself. And so it's the aggravation factor. We'll put up with the vendor wanting more money before we're going to go out and do a procurement for just another one agency. Just means we didn't think very well. In this instance, it is very possible that if the RFP had included both the fixed price for the 5 agencies, so we could have done that, and had a section that would have asked for a fixed rate per minute for other agencies other than the 5, possibly if we'd have done that from the very beginning, would have had the flexibility we wanted and probably would have gotten a lower per minute price than we end up going back to the vendor and negotiating for. So it just means we didn't think well enough. Okay. Any questions on that little example? So that's our final modification example, and you're saying good riddance. Let's move on. Okay, so I'm coming back to 2 sayings mentioned on day 1 of the class, pay me now or pay me later, and this other thing I mentioned just this morning. It's all meaningless boilerplate until it isn't. As state procurement and contract management personnel, you are supposed to know what boilerplate and other requirements to include in the solicitation contracts to begin with. That's part of your job. You're supposed to know what to put in there versus what not to, and to properly apply those requirements when the time comes. It's one thing to have them in there, but you have to know when it comes time to trigger them so that you know what is to be applied at the time when you have an actual situation. So you have to use your crystal ball, and you go to your procurement people, and you go to your assistant attorney general, and hopefully come up with the right answers. Let's see, the what would you do exercise is in the case study exercise, which we haven't done yet. That's right, we still haven't done that one. Maybe I should do that.
Yeah, Friday.
Yeah, I have to do that Friday. It's the one I haven't given you yet.
Does that mean we're going to need an extra day?
No. That will not take an extra day, believe me. It either won't be done, whatever. That the key to procurement and contract management issues is to learn from problems and take steps to prevent them from recurring. Fool me once, shame on you. Fool me twice, shame on me. All right. So now we're moving off of modifications. We're on to novations, which means an assignment. So take a deep breath and get ready to move into a different thought process. We frequently have language in our specifications that is not mandatory, but it's language that usually is in there, that says the state contracts cannot be transferred without the written consent of the procurement officer. The other thing that is in there, and most people don't know, is there is a provision in 21050224A that says the contractor may assign monies receivable under the contract by providing notice to the state. If a vendor wants its payments to go to somebody else, like a bank, all they have to do is give notice to the state, and the state can make the payments to the entity that the contractor directs them to be made to. That is not an assignment. That is an assignment of payments, and per this section, all the vendor has to do is give us notice so that we know the vendor wants us to make the payments to this entity, and we make the payment, because that isn't changing anything else about who's responsible to perform the contract. And what vendors sometimes do excuse me, is sell receivables. They'll take loans against the contract. They'll take loans against receivables, and the collateral sometimes is the payments from the state. And so if a vendor gives us notice, we can make the payments directly to the financing entity that they identify. Other than that circumstance, the contract itself cannot be transferred without the consent of the procurement officer. Yes?
Does that written notice have to be something official that's got to be signed off by the AG, physical, anything like that?
Does the notice have to be? No, this is coming from the vendor. The vendor has to put it in writing.
Right.
And it has to be signed by someone in a position of authority from the vendor, but it's not something that requires legal sufficiency. It's not an agreement. It's them just telling us, instead of paying it to me, pay it to M&T Bank at account number such and such, PO address such and such, and signed by Tom Jones, president.
And then is that notice given to physical, so they know?
Then that would be given to your accounts payable, so that they set it up, and I guess that not them, but the controller's office, but someone sets it up to make the payment to that entity rather than the contractor itself.
Okay. Now, does something have to go in Venus as far as alternate names and stuff like that? And things as
I would assume that you need an entry in AdPix to allow the payment to be made, because one of the things AdPix is supposed to do is not allow you to make payment to a vendor other than who
it's on
the number is set up for. So something has to be done, a change order or something. And I will admit AdPix is far from my strong suit. Mark claims even less knowledge than me.
I boast even less now.
Okay. All right, so we're moving on now, talking about the assignment of the contract. Successor in interest. If the contractor sells itself, what did I say, is stuff? If the contractor sells stuff, sells itself or just the contract, the state can, when in the best interest of the state, enter into a novation agreement provided that the original contractor, who is the transferor, and the proposed new contractor, the transferee, agree that the transferee assumes all of the transferor's obligations. Number one, whoever is going to buy the contract, if we permit it, has to agree that it is taking over all the responsibilities of our current contractor. In other words, we supposedly are losing nothing in the process. We're not going to get someone that can't do the job, is going to do it to a lesser degree, something of that nature. The transferor, our current contractor, needs to waive all rights under the contract. So once this is in effect, if it is agreed to, they will not have the ability to bill us anymore. They will not have the ability to file claims anymore. So they're basically saying, if this is approved by the state, we, as the contractor, are completely out of the picture in every respect, lock, stock, and barrel. And by the same token, whoever we give it to has to do everything we would have done if we would not have transferred this contract. And either the transferor guarantees the transferee's performance. That we're saying, even if we agree to this, even though the current contractor does not have the right to come against the state for anything, we still have the right to go against the current contractor if the vendor that they're assigning it to doesn't work out. So we lose nothing either way.
I wouldn't have thought that would have been the case.
Well, we don't want this, probably this is better if I go to the next slide, because I'll probably explain this better. We don't want to lose something. We're not the one that's saying to the vendor in this instance, we want you to transfer the contract to somebody else. They're coming to us and saying, we've been bought, we're selling ourselves, we're trying to get rid of this line of business, we want to give your contract to somebody else, and we had a certain deal when we contracted with that vendor. We don't want to come out worse for that deal because the vendor simply gives it away and says, okay, I'm out of the picture, I don't have any more responsibilities, and the vendor that gets it can't do the work or it's quibbling about details or things of that nature. We don't want to be worse off, because if we think we are, we should not agree to the transfer. It's that simple. So going back to, these are the requirements that we should make sure are there before we agree to this. So the one getting it agrees to assume all the obligations. The one giving it up agrees that they will have no more right against the state. And either we get the prior one guaranteeing the performance of the one they want to give it to, or we get some kind of a bond that is going to be the guarantor instead of the vendor itself. We're requiring them to get a performance bond or something like that, so if things don't work out, we have something to go against. Now here's why. Yeah.
When you do the assignment and say if the original contract required that original bidder to give a bond and stuff like that, you still in turn have to go to that transferee and get new bonds, a new contract affidavits, anything like that?
Question is, if you had bonds from the vendor that wants to give it up, do you get bonds from the new vendor? Yes. We should lose nothing. From our standpoint, we should not knowingly accept anything that's less than what we had before. And in fact, not only should you get the same level bond, but you might want a higher level. And we can do that. We can say, no, unless you double the value, we're not going to agree to the transfer. Because we don't, in so many words, we don't have the same confidence in this new vendor that we did in the vendor we awarded it to begin with.
Do you still check references to make sure they can perform?
You do whatever you think is necessary to give yourself a comfort level that this new vendor is someone you want to be contracting with. And I say that because, with some caution, because sometimes you don't have much choice, which I will get to in these slides. Now here's one of the things that sometimes happens, and this is one of the reasons why we're protecting against things. Sometimes a contractor creates a new subsidiary and seeks to spin off the contract from the parent or from one subsidiary to this new one. Usually the primary reason for the contractor to do this is to reduce its exposure to liability. And what that means is they want to shield the parent or major subsidiary from a potential loss. Usually the newly formed subsidiary has little or no assets and might simply declare bankruptcy if there is a major judgment against it. Excuse me. But the very reason why, in this situation, the parent wants to do this is the reason why we typically shouldn't agree to this. Because one of the things, and maybe I just need to read the slides, but it's the issue of who has the deep pockets. And the parent company is the one that traditionally has the deep pockets. I remember one time when I was here, we had some kind of a medical contract, I think to serve the medical assistant or something like that with Blue Cross. And Blue Cross wanted to create a new subsidiary and transfer the contract to this new subsidiary. And we, for several months, just said no. You said, why are you creating this new subsidiary? And they were trying to get it off their balance sheets. They're trying to get the liability for this and other similar types of contracts off the balance sheet of the parent corporation. And that's not a good comfort level, that the reason why a vendor wants to do something is to sort of absolve themselves of liability so things look better on the balance sheet. That means they're transferring it to a subsidiary that's in many cases a hollow shell. One of the things we did in that case was go back to Blue Cross and say, okay, what assets, since you're creating this new subsidiary, what assets are you going to transfer to them? What do they have that if they don't perform the contract, we can go against to try and get some relief? And initially, they weren't going to transfer any assets. You were going to have this hollow shell, and if there was any issues, then nothing would transfer back up to Blue Cross. And they did this because it was better for them, and for that exact reason, it was worse for us. We would go to somebody with no assets, no track record, so we just said no, until finally I think we got them, not that we got them, finally we said, for us to even do this, you need to come up with, put up some assets, come up with a performance bond and certain other things that we made them do. And when they finally did that, then we agreed to a novation. But until they did it, we just continued to say no. What is good for the parent is often bad for the state. That's why if it's bad for the state, you don't do it. The very reason firms want to do this, shield the parent firm from losses, is why this assignment usually would not be a good deal for the state. We want a vendor with deep pockets in case there is liability. So agreeing to the assignment of the contract from the parent to a subsidiary means we are losing leverage in case of a liability. Usually the state would not agree to such an action without an additional inducement. Additional inducement. Additional inducements can take the form of a guarantee that the parent will still be responsible for the affairs of the subsidiary. Even though they're doing it, I still am going to be responsible. If something goes bad, you can still come back against me. Or newer increased levels of liquidated damages or bonds or insurance. A price decrease. For me to agree to this, there has to be some reason. Charge me less money. And if you charge me less money, maybe I'll agree to this transfer. If you want it badly enough, just cut your prices. Or without a decrease in price, some other increase in deliverables without a change in price, so we're getting something more, again, as an inducement. If an agency doesn't agree to a novation, the contractor is not permitted to complete the transfer of the contract. They can't just do it without our approval. In some instances, this legal impermissibility may dissuade the contractor from completing the transfer. However, in other instances, and this is where you kind of come to the reality, the sale, merger, etc. has occurred before the agency is aware it's happened, and it's difficult, if not impossible, to make the contractor undo the transfer. I remember many things. I got on memory lane often, but I can remember here when there was a food service contract, one for Carter Center, Finance Center, and Upper Shore Community Mental Health Center. And the vendor was Service America. And then one day, here comes a bill from Nutrition Management. And it's like, why are we getting a bill from Nutrition Management when the vendor is Service America? And so you call Service America and you found out that, well, Service America sold their food service unit to Nutrition Management. Never said anything to anybody, but they sold their unit. And now Nutrition Management says, we own your contracts. And our answer is, no, you don't. You have not come, no one has come to us, no one has asked us to assign the contract. So we still expect the work to be done by Service America, and we will only pay invoices to Service America, no invoices to Nutrition Management because we don't have any contract with Nutrition Management. Yes?
Just answered my question. I was going to say, if they invoice you and we have a contract with them, how can we possibly pay that?
You can't pay. You can only pay the vendor that is identified in the contract, even if the vendor wants to simply change its name. You have to do a novation. There's official legal change in the name. And you can only pay the entity that is in AdPix of who it's supposed to be. Because otherwise, for all you know, you're paying a fictitious corporation that, let's say, does hacking of accounts payable from a vendor and is diverting the money, and the contractor is still waiting for payment from the state, not knowing that someone else has, in so many words, intercepted the payment. So we don't get in that situation. We pay the entity that the contract is with. If we get one of those notifications to pay somebody else, then we can do that upon the written notification. But to just say, okay, now the contract is with Nutrition Management, not Service America, well, not until you come to us and you go through these other things that we said back here. In this case, we had to have Service America come to us and ask for the assignment. We had to have Nutrition Management agree that they would 100% fulfill every requirement of the contract that Service America had. So we needed written confirmation. Nutrition Management was going to do everything that was required, including the same price. And we had to have insurance that Nutrition Management had the capability of doing it. It's one thing for them to simply say, yes, I will, but once the assignment is done, what if they can't? What if they don't meet the same time frames? What if they don't keep the same staff? What is our protection that we went through the evaluation process, we vetted Service America, we didn't do that with Nutrition Management. We didn't have anything from Service America saying, I'm going to give up all my rights under this contract. So we did not have these two things. And at that point, we had no additional guarantee. We just had pay now Nutrition Management rather than Service America. So we had to go back and tell them, we need these things. And until we get these to our satisfaction, we're not going to pay anybody. All right, so we're back to this issue. And in that instance, the first that we knew that Service America had sold their food units to Nutrition Management was when the bill came from Nutrition Management, which is not a good time to find out, plus the fact that despite the fact that our contract says you can't sell the contract, it's the old adage of possession is 9/10 of the law. Well, they have done a legal sale. So they've Service America sold their entire food service unit to Nutrition Management. Not just our contract, but perhaps dozens of contracts. And the people, supposedly, the employees went from Service America to Nutrition Management. Supposedly everything was a complete transfer. And now we're going to say, nope, can't do it. Can't do that sale, when it, in fact has legally already happened. So our best recourse at that point was, well, you have to go back and you have to make things good from our standpoint before we're going to pay you any money.
Check.
We hold the check, and that's what we did. And they were getting irritated
Sure.
because they wanted to make payroll, and they had bought this company, and supposedly they'd paid good money. And they wanted the money to start rolling in now to help pay them for buying the food service unit. And the first thing we're doing is saying, we're not going to pay you any money. You need to make application. You need to start signing these things. We need to get this document from Service America. We need to get this document from Nutrition Management. We need, I don't know whether we asked for more bonds or anything like that, but we started, we upset the apple cart to some degree. So even though in that case the deal was done, what we did was what it says here. We notified the new entity it had violated the contract provision. We didn't pay until and unless the vendor requested a novation and complied with any and all requirements, the ones I just went through, those 3 things from a couple slides ago. And said, now this is not a good omen for performance if you come in here and the first thing we know that you exist is when you say, all right, where's our money? And it's another way for us to demonstrate, number one, we know what's in the contract, and number 2, we expect compliance with the terms of the contract. So at the very least, you don't pay. Now, going down the road a little more. So you say, all right, I'm not paying you. What if the vendor still doesn't comply with novation requirements and stops performing? Well, if you don't pay me, I'm not going to do the work, which can happen. So it's like, who's going to chicken out first? I don't pay you till you come in and get approval. Well, if you don't pay me, I don't do the work, and I don't do the work until you pay me. So you come up with this difficulty, and that's where you have to decide one or the other. Either you're going to, and it depends on where you feel you are in leverage standpoint, in capability of doing other alternative standpoint, but you have to decide whether either you're going to back down and accept the novation under the vendor's terms or terminate the contract for default, if it gets to that point because they stop performing. If they stop performing, you need to do something. And I don't know if that something is give in, but it's something you will have to decide. And this is something that perhaps you would have made some contingent plans before you entered into this of what does it happen? What do you do if it happens? The other thing you could do is an emergency. Terminate for default and do an emergency. These are possibilities. Or may not be the best of things, but we don't feel we have much of a choice. The vendor seems to be okay. We don't want to do an emergency. We don't have someone else ready to take their place. So we acquiesce, we approve the transfer. It may come to that. You have any words of wisdom? Drink some water. That's his words of wisdom. Let's see, do we have more on that?
Joe, I can say one thing about that.
Say one thing about that while I drink.
We did have a very complicated novation not too long ago. It concerned a nonprofit that was changing their name. But actually what they were doing was selling the company. And it was a subterfuge. The name change was a subterfuge for the principal of the A company to sell it to the B company. And it took a little bit of doing to unearth what exactly was going on. So my advice is, when you do get these, definitely get your AAG involved. It's a legal document. It's a potentially difficult thing to determine whether or not the people are telling you the truth.
You say stop payments and investigate.
Well, this was a beneficiary service, and they didn't want to stop having the service performed. But on the other hand, we did not grant the name change until there were certain assurances from the first party.
Because you said it was more than a name change. It was a sale of the contract entity. All right, which is a coincidence. We're going now into name changes.
There you go.
Transition. So what we just talked about when there's a sale of the contract, a sale of the company. There's other times when a vendor simply changes its name. And it's the same company, but it's now called something different. So we still have to have the correct legal name of the company to make payment to. So in this instance, the contractor should request that its legal name be changed in the contract. The procurement officer shall enter into an agreement that affects the name change and states that no other terms and conditions are changed. So if that situation, we're just going to change vendor A to vendor B, and nothing else changes. But it's still done by the procurement officer in a legal document, so everything is nice and tidy. And you know you can now pay B rather than A in terms of the name. A successor in interest of novation may be considered a material change to the contract, thus the assignment may require BPW approval under the rules for modification. May. So that depends. You're going to have to go to your assistant AG. I've talked about what's a material change. Material change is whatever you think is material. And is changing the contractor material? Some people think any time you change the contractor, that's material. Other people don't think that's material. So you go to your assistant AG, have them look at the entire circumstances, and someone will make a decision whether they think it's something that has to go to the Board of Public Works or whether it doesn't. Let's see. A name change itself. Successor in interest is when the company is sold. It goes from one entity to another entity. A name change is the vendor's the same vendor, it's just changing their name. So that is not a material change, thus it does not require approval outside the agency. And I'm trying to think of an example. I know years ago, well, Verizon. Verizon was Bell Atlantic, and it changed its name to Verizon. So it's still the same entity, just changed its name. So that is the one that simply gets done legally, but it doesn't require any approval by the Board of Public Works. The one of Service America versus Nutrition Management, that was successor in interest. That did require Board of Public Works approval. So you have to look at the specifics. Okay, let's see. Contract modification approval. Let's see. So what are we saying? Approval thresholds, steps, and timeframes are discussed in the overview. So what you will need is approval, the controller's control number to indicate that the vendor is registered to do business in the state of Maryland, is paying their taxes. That's where you come in with assessments and taxation, labor licensing, regulation. Your assistant attorney general is involved. Your agency is involved. You have to sign a thing here. I don't know whether your fiscal people have to sign. You may have to go to the control agency. You may have to go to the Board of Public Works. So that's what's necessary depending upon the modification that you want to enter into. That's any modification, not just the novation we were talking about. Notification. The procurement officer should send a copy of the fully executed contract modification to the contractor and to all interested parties in the agency, including the project manager and the contract manager. So we've said a number of times, only the procurement officer can approve a modification. And once the procurement officer does that, once everything is legally constructed, signed by the vendor, signed within the agency, then the next step is to get the modification in the hands of the person or persons that are going to go through the day-to-day monitoring of the contract, so they now know what the contract has been changed to reflect, to require, to pay, whatever the circumstance is. Let's see. And all modifications, so this is not exactly part of notification, but it's still something to throw in. All modifications must be in writing and go through the procurement officer. Cannot have verbal modifications. The saying is, a verbal agreement is not worth the paper it's printed on. At least 2 people laughed. Thank you. I didn't create it. I'm just repeating it. All right. Any questions on novations? Terminations. State may contract the termination in whole or in part, and there's 3 reasons why the state may terminate a contract. Lack of appropriation for multi-year contracts. And multi-year contracts means contract that runs more than 1 fiscal year. And you can have a 2-day contract that is a multi-year contract under that definition. If a contract starts on June 30th and ends July 1st, it is a multi-year contract from the interpretation of the state in terms of going beyond 1 fiscal year. So that's what multi-year means in the state nomenclature. Yes?
So if you have a contract that is only for 1 year, suppose the appropriation is cut.
What is the what?
You're saying lack of appropriation for contracts that run more than 1 fiscal year.
Right.
What if your funds are cut through the year?
That does not apply as a reason for termination. I'll get to that, which we'll have some specific detail on lack of appropriation. So I'm giving the overview of the 3 ways you can terminate. Lack of appropriation, if you have more than 1 fiscal year involved. Convenience of the state, default by a contractor. So lack of appropriation, termination for convenience, termination for default. Those are the 3 ways the state can terminate a contract. The right of the state for all 3 types of terminations is contained in mandatory clauses in virtually all state contracts. You will have a mandatory contract term for termination for convenience, a mandatory contract clause for termination for default, and a mandatory contract clause for lack of appropriation, which sometimes is called the funding out clause. And if those circumstances happen, you have a clause that states what's going to happen in those circumstances. Terminations of any kind are rarely done by the state, and the rarest one is that one. I don't know if I've ever had one that falls under that strict requirement. I have done both of these. I can't remember doing one of those because usually it doesn't happen. And we're going to talk about termination for lack of appropriation. We've made the statement before under one of our examples, the one about adoptions together when we talked about Schaefer wanted to know who was going to get fired. And it goes back to Finance and Procurement Article 7234 that no state employee may obligate the state to make a payment in excess of appropriations. And employees violating this prohibition can be fired. Now, when you go to a fiscal year, and if you think about it, you have funding for the current fiscal year. And until the budget is submitted to the legislature in the spring, and a budget is passed by the legislature by, I think, the first week of April of each year, and then it goes to the governor for signature, until that happens either sometime in April or more likely sometime in May, you have no appropriation for the following year. All you have is the appropriation for the current year. And if you only have an appropriation for the current year, that's the only thing that you can deal with certainty. Because until you get into May or June and you have the following fiscal year actually passed as far as what the budget is, you don't have any appropriation for anything other than the current fiscal year. So state appropriations are only approved 1 fiscal year at a time, except for this May or June when you have the second one. Because the above 2 bullets, contracts covering multiple fiscal years should never be entered into without the means to prevent over expenditure. How do you do a 5-year contract that supposedly obligates the state to, let's say, spend $10 million when all you know is I have an appropriation for the 2000 and we're in 11 now, for the 2011 fiscal year. Well, how can I obligate the state to 2012, 2013, 2014 when all I do is have an appropriation for 2011? And the answer is you can and you can't. You can because you can sign a contract, but the contract does not obligate the state because it has the funding out clause, the lack of appropriation, that the contract is canceled if in the future funds are not appropriated. So you don't have to worry about getting an appropriation currently because, number one, you can't for 2 and 3 and 4 years in the future. And when you get to that point in time, if you don't have money, then the contract is terminated because of a lack of appropriation. Now, there's some caveats to that. Let's see. Means to assure over expenditure doesn't occur. The means to ensure over expenditures doesn't occur is the termination for lack of appropriation clause, also known as the funding out clause. The funding out clause comes into play if the necessary funds to continue a contract in a future fiscal year are not appropriated. In this situation, the contract automatically ends as of the first day of the fiscal year for which the funds were not appropriated. So if you come to July 1, 2012, and there was no money appropriated for the start of the 12 fiscal year, the contract is over as of July 1, 2012. But there's some other details. The rights and obligations of both parties are unaffected through the end of the fiscal period for which funds are available. So it doesn't affect anything for the period when you do have funds. And here's the caveats. Number one, the agency has to request the necessary funds to pay for a fiscal year. You can't just go 3 years from now and to get out of the contract, don't even make a request in the budget for the funds and then say, sorry, no appropriation. You have to make a good faith effort to get the money. And basically, it has to be the legislature or the governor or someone in a position of authority that prevents the appropriation from happening, not you not asking for the funds, which is what that says. And the other thing, if you have an indefinite quantity contract with no guarantee of usage, you don't have to make a funding request because there's no obligation for usage to begin with. So we're talking about fixed price contracts or things of that nature where there is some obligation of what the contract is to cost and be paid for. The agency, and if you ever invoke this, and I have seen some write-ups about other states or other agencies that have done this and some of the pitfalls they have had to overcome to get this to be legitimate. The agency may have to demonstrate it doesn't have sufficient appropriations to cover an upcoming fiscal year. If a contract is covered by a general appropriation rather than a dedicated one, the agency may have to prove that it cannot divert funds from another proposed use of the general appropriation rather than take funds from the contract.
This is the shell game.
Well, what that means is many times your contracts do not have a specific appropriation that says we have $500,000 appropriated for this purpose. And if you don't have it to a line item detail, just the fact that you're deciding internally that, well, we want to use our appropriation for a different purpose now may not get to the level of a lack of appropriation. In so many words, this is hard to apply. And if it is ever applied, which I can't remember seeing again, you may have to prove that you didn't have the appropriation, you had to ask for the appropriation, it was denied, you had no way to transfer funds within the agency to make up the lack of appropriation from another source, all before this particular clause might kick in. Let's see, the actions described in the caveats may be necessary if the contractor files a claim that the funding out provision was inappropriately applied. However, despite the mandatory existence of the funding out clause, it has rarely been implemented for state of Maryland contracts. This is the kind of thing that, even though it's a mandatory clause, and I have seen this when you go to government after government, whether they're local governments, whether they're other states, every government has the equivalent of a funding out clause for lack of appropriation. But for the most part, they're never used, because if they started being used, then contractors would become much more hesitant to sign contracts that had funding out clauses. And so the very fact that we can get away with funding out clauses is because we rarely use them. It's like insurance. You can get insurance up to the point when you use it, and then once you use it, you have difficulty getting insurance from that point on because you've used it. So that's,
Very right of the contractor like when you cancel for convenience, they have certain rights, but under a cancellation for lack of appropriation.
well, they could file a claim and say that you didn't try. The question is, does the vendor have any right, and it's in one of the slides there, that if they feel, well, it's this one. If the contractor filed a claim that the funding out provision was inappropriately applied, if you say you have no money and the contractor has reason to believe or just wants to try and have the contract continued, they can file a claim and basically say you need to prove that you didn't have the money and you didn't try to get it from another source. And if they file that, I don't know what the result would be. It depends on how meticulous you were in trying to make sure you had the money. And again, I can't name an instance that was applied. Probably has, but I can't tell you one. But it's a mandatory clause and it's a right that's there. Let's see. Termination for convenience, a T for C. This allows the state to terminate the contract in whole or in part whenever the state determines that such a termination is in the best interest of the state. Contract should be terminated for convenience when the agency no longer needs the services and the estimated total cost of termination is less than the total cost of continuing the contract. Don't need the contract, and the cost of termination is less than the total cost of continuing. And we'll talk about that. For a termination for convenience, here are the requirements. The state must pay all reasonable costs associated with the contract that the contractor has incurred up to the date of termination. This is, shorthand for this is incurring expenses. State must pay all reasonable costs associated with the termination. The state does not pay any profits that the contractor expected to make that have not been earned as of the date of termination. So we're on the hook for incurred expenses in terms of what they have actually spent and what it takes to get out of the contract if we terminate for convenience. So we're on the hook for expenses and the termination for convenience. And we have the right to terminate for convenience at any time. One of the things that I used to see all the time many years ago was a mutual right of termination by either party, by the state or the contractor. And I say many years ago, I'm talking about even longer than 1981, because 81 is when Title 21 went into effect, and since that point, only the state has the right to terminate for convenience. And I have had instances where contractors say, well, I want this to be mutual. I want to have the right to terminate for convenience as well, and we cannot permit a vendor to have a right to terminate for convenience. That is a state right only. And I've had vendors that say, well, that's not fair. It's not fair if you have the right to do something and I don't. And my answer is, it is totally fair. We told you what the circumstances are, and you tell us by how much you're going to charge for the contract, what that right is worth to you. And so if you don't like the fact we have the right to terminate for convenience, either you don't sign the contract or you charge enough that it's worthwhile to you despite the state having that right. We cannot give away our right to terminate for convenience. We cannot allow a vendor to have a right to terminate for convenience. Let's see, there can be circumstances, and here's the thing. All right, let's see. There can be circumstances when the state agrees to terminate a contract for convenience rather than default, with the provision that the contractor not have the right to seek incurred expenses. I have had instances where we have difficulty with the contractor, and we really think they are defaulting on the contract, and we really would prefer to terminate for default, except that vendors somehow don't like the notion of being terminated for default. They think that somehow somebody could construe that to be a negative aspect, that perhaps it would not look good on their reference sheet that, yes, the state of Maryland terminated me for default. Not a positive. So there are vendors that will fight the default circumstance. And as I said probably on the first day, a lot of times it comes down to how well you have documented the vendor's lack of performance. And many times, if you are claiming the vendor didn't perform, but you don't have the documentation, and so you're not sure if you go and the vendor actually contests a termination for default, you're not sure if you have the documentation, what you might do is basically try to negotiate this. Well, all right, if we don't say it's default, we say it's a termination for convenience, which again, the vendor cannot contest a termination for convenience. But we can say, well, how about this? Even though we don't think you're performing, we'll call it a termination for convenience, but we don't want to be on the hook for incurred expenses because in reality, we're doing this because you're not performing. So we can reach an agreement with the vendor that we call it a termination for convenience, but the vendor gives up their right to seek incurred expenses. And then supposedly both parties, I don't know if they're both happy, but at least you should not be into some kind of fight over the termination and then perhaps expenses for the termination. So this is a possibility you can do. And there could also be provisions in contracts or contract modifications that the state can terminate earlier than the listed expiration date without liability. We talked about this morning about 6 months with the ability to get out after 3 months without liability for an extension, that kind of thing. So if the state is unsure whether to exercise a 1-year option, a mod might be done that allows the state to terminate after 6 months. You don't know whether you want to exercise an option, do a modification that allows you to exercise but get out without liability. These are things you can do. And that way they are terminations for convenience, but without potential liability to the state. So, example number 1, 1988. For the first time, infant formula manufacturers started bidding to give a rebate off of the retail store shelf prices on infant formula purchase with WIC vouchers. Infant formula did then, and probably still does, account for over half of all WIC food costs. And WIC generally spends in Maryland more than $100 million a year, so you probably have $50 million or more a year spent on infant formula. So it's big numbers. Infant formula accounted for more than half of all WIC food costs. Rebates were as high as $1.25 on a can of formula that at that time had a retail price of $1.60. So you do the subtraction and you say, so all you're paying for it is 35 cents for a $1.60 can of formula. Yeah, and your question is? At that time, Maryland had contracts with 2 companies to provide home delivery of WIC foods in 4 jurisdictions: Baltimore City, PG, Anne Arundel, Montgomery counties. So these jurisdictions had enough density of WIC recipients that it made sense to contract with a vendor to actually deliver the food items to family by family, house by house, rather than have them go to food stores and pick them up like they were in the other 24 jurisdictions in the state. These 2 companies bought the WIC-approved foods in bulk and gave WIC a discount versus the prices in food stores. Even with the high cost of home delivery, these contracts were still less expensive than paying full retail store prices. By far, the biggest cost savings was in infant formula, by the vendors buying in bulk and charging less than what it would cost for the people to go in the store and buy them. Now, in 1988, we did this bid for rebate, and you only had 3 vendors that manufactured infant formula, so you had 3 vendors that could respond. And when we did the procurement, the winning bid came to, we ended up paying 25 cents a can. In other words, that the WIC program would give a voucher to a family to go and buy 20 cans of formula. They'd go to the supermarket and give the voucher. The supermarket would charge the full shelf price to the WIC program. Then the WIC program would send the voucher to the manufacturer, who would send them a check for all but 25 cents a can. So the net price to WIC program is 25 cents a can. Now, obviously, if you're paying $1.60 and getting back $1.35, so that all you're paying is 25 cents, that is a really lucrative contract from the state perspective. That means we were getting millions of dollars per year back under rebates. Let's see, once the infant formula rebate contract was awarded, the home delivery contracts became too expensive to maintain. Whereas the home delivery contract might offer 50 cents off the retail price of a can, so 50 cents off of $1.60 or so, the rebate price was $1.35 off per can. So obviously, a whole lot less expensive to go to the rebate contract than to continue with the home delivery contracts. The savings of the rebate contract versus the home delivery contract was something like $210,000 per month, $7,000 a day. So every day we continued with home delivery versus going to the rebate contract, it was costing the state $7,000 versus what they could be paying. So the same day that we got the approval from the Board of Public Works and that we got the contract signed by the Secretary of DHMH, and we had it transmitted to the vendor, and that same day, I, as procurement officer, terminated the home delivery contracts for the convenience of the state. We no longer needed home delivery because we were saving $7,000 a day by going with the rebate from, wasn't Similac, it was Infamil, Mead Nutritional. So I did a termination for convenience, and that's the typical termination. We don't need this contract anymore. Nothing the vendor was doing, and the two vendors were doing that caused default. It's just, it cost us too much money to maintain it. So let's see, I terminated for convenience with appropriate notice of the vendor's rights under a termination for convenience and a requested response time for any claim. So I told them we were terminating, and we were terminating immediately, and now please come back within, and I don't know whether it was 2 weeks or whatever, and identify any cost of termination as a result of this. And again, only procurement officer can do a termination. So I sent this to the two vendors. Under a T for C, the vendor may be paid for incurred expenses that had not yet been amortized. A notice of claim was received from one of the vendors for about $90,000. The second vendor never replied. Never got a peep from the second vendor. So, all right, we've terminated, it cost us nothing. Now the one said, all right, $90,000 is what you need to pay. This is back in 1988. And that was Greenspring Dairy. According to the one vendor, Greenspring, the $90,000 claim represented the cost of food on hand that it now claimed it couldn't use. I have this warehouse full of peanut butter and infant formula and cereal and juice and all this kind of stuff, and now that I don't have this contract, what am I going to do with this food? So you, the state, need to buy it back from me. That within the past year, they said they had bought a phone and computer system specifically to handle the orders from those 4 jurisdictions. You're talking about thousands of people who had WIC vouchers who were calling in orders and things like that. Just before the bid occurred in response to complaints. So because of complaints, they went and spent money to buy a new system to get a better phone system. And they had leases vans that they had to deliver the food. So, would you pay any of this claim, any or all of the claim? Yes?
I would say yes.
Yes? Some of it?
It's got to be documented.
Which sum would you pay?
The food on hand and the leases of the delivery vans and the certain other items that might have been specific to delivery. That was something they did on their own to make it better for their constituents, but even so.
If we wouldn't have the WIC contract, we wouldn't need a new phone system. And our contract was to run another 2 or 3 years. If we'd have known we were going to be terminated like in 3 months, we never would put that money out. And without the WIC volume, we didn't need it. Our system was fine for what we had other than that. Anybody else? Yes?
If they can prove the claims, then yes.
If they can prove the claim, pay them. All right. How many people agree? Yes, pay them something. Maybe we don't know exactly how much yet, but let's see. We owe them something. We're all agreed on that. All right. What was done? The procurement officer asked the vendor for proof of the level of inventory. Okay, you say you have peanut butter and juice and cereal. Tell me how much of each you have and give me the invoices of how much you paid for it. And since you're Green Spring Dairy, Green Spring owns Royal Farms. There was Royal Farms, Highs, was there a third one? I think they owned Royal Farm. So it's like, and not just prove that you have the inventory, but tell me why you cannot use it in your stores. Not saying that it wasn't going to be a hard proof. Maybe they can just say, we don't sell that stuff in our stores. But they did have to prove their level of inventory and what they paid for it, and that it wasn't spoiled, it wasn't over, past expiration date, something like that. That's the effort to dispose of. You try to resell it, try to return it, and can you use it? And I still think it was Royal Farm. So tell me the efforts you have made to get rid of this food other than us paying for it. Okay. Proof of the cost of the phones and computers. All right, I want to see the invoices for the installation of the phone system, and I want to see the actual lease agreements for the vans showing they could not be canceled. So they came in with $90,000 for those 4 activities, and I wrote back and I said, fine. Now, proof of this, proof of this, proof of this, proof of that. What we also said was that anything that WIC ended up paying for, WIC owned. If we're going to pay you for it, we want what we've paid you for, other than something that's an installed activity, such as the phone system. After 2 sets of correspondence, me to the vendor and the vendor back, the vendor never responded with any documentation, never submitted a formal claim, never was paid 1 cent. We expected to pay thousands of dollars. We were ready to pay thousands of dollars. The vendor ultimately never came in and never was paid a cent. So a clear example, we terminated for convenience. A clear example, they were entitled to something, but we don't just say 90,000 is it. Okay, we'll pay you 90,000. And because they didn't come back and document a thing, we ended up paying nothing. So that's one example. Another example that I remember well, treatment and learning centers. Maryland State Board of Contract Appeals, case 1746. Treatment and Learning Center, TLC, Tender Loving Care, had a contract with DHMH to provide treatment to brain-injured individuals that needed specialized care. Such contract activities are called human services. DHMH has many contracts for human services. Did you know that?
I did.
You did? Well, I'm glad. I should think you would. And has a manual specifically describing the special circumstances that apply to these contracts. Let's see. Oh, I guess I should go in the right direction. This special manual is called the Human Services Agreements Manual. The manual's contents are incorporated by reference into DHMH Human Services contracts. One provision of the Human Services Agreements Manual was that a vendor could request to be let out of a contract if financial or other circumstances made it impractical for the vendor to continue under the contract. So there's a provision the vendor can ask, make a request to get out. Cannot terminate for convenience, but can make a request. And all vendors covered by this manual were nonprofit organizations, usually with limited financial resources. That's why there were special considerations given for these type of vendors. July 31, 1992, citing this provision of the Human Services Agreements Manual, Treatment and Learning Center requested to be let out of the contract as of 60 days later, stating that it was losing money performing the contract, which imperiled its very survival. We're nonprofit, we don't have much funds to begin with, we're losing money, so if we continue with this contract, we're going to go belly up because we just don't have the resources to continue providing this service at this expense, even though they had just signed a new 3-year contract something like 6 months earlier. And what I thought at the time is, well, if you knew you've been losing money for a couple years, why did you just sign a new 3-year contract knowing all the while you were losing money? It just didn't make sense to me. But all right, that was not the issue at that time. The Human Service Agreements Manual clause at issue said that such a request might be granted if the involved DHMH program had at least 60 days notice and could find suitable alternate care for the affected clients with another qualified vendor. So the one vendor could make a request at least 60 days in advance of when they wanted out of the contract, and we had to be able to find some other vendor to take the clients. So those are the two conditions. In this instance, such alternate care was arranged as of 11/15/92. So if you go back in time, what did I say? They made the request July 31st, so 60 days later is August, September. Around October 1st is when they expected the contract to be over. And what actually happened was it was 6 weeks later before arrangements were actually made to transfer the clients. And as of 11/15, Treatment and Learning Center was released from its contract on that date, about 6 weeks after the 60 days. Within 30 days of November 15th, TLC filed a notice of claim with the procurement officer, and within 30 more days, an actual claim was filed for $24,496. So if you'll notice, we said on Friday that claims, you have a notice of claim within 30 days of the date the basis for the claim was known or should have been known, and within 30 days of the notice, you had to file the actual claim. So they met those time frames. They had two bases for the claim. Number one, the contract was terminated for convenience, and number two, they incurred extra costs under the contract for the 6 weeks past when they asked to be let out of it. Now, I will tell you, when I got this, I said, you got to be kidding me. They asked to be let out of the contract. We go to efforts to try to accommodate their request. We try to find another vendor that's going to take them, and you have to have very detailed plans to transfer a client from one provider to another. And then we let them out, like 2 years before the contract is due to expire. And because it's 6 weeks later than what they wanted it to be, they're coming to us and saying we owe them $24,000. My reaction was, you've got to be kidding. I probably had a reaction a little stronger than that, but you get the gist. The claim was denied, primarily because DHMH contested that it is terminated for its convenience. And I argued this, and my attorney said we were on firm ground. The argument was that because the Human Service Agreements Manual was incorporated into the contract by reference, and the manual had the provision for a vendor to be let out of a contract, this was essentially just implementing a contract provision, the same as a provision for a contract to end on a specific date or due to a specific circumstance. My logic was, since this provision is in there that says they can get out within 60 days if we agree to it, that's no different to saying the contract's going to be up on August 31st and it ends on August 31st. I don't have to pay you because it's over on August 31st. It just ends. So my logic was we didn't terminate. There was a contract provision. They made a request. We granted the request, and we were implementing a contract provision. We were not terminating, in my mind. Aside from saying there was no termination for convenience, we also denied the claim on its merits, and that's something that I recommend you always do. You address every possible issue that a vendor raises or could raise, so that no matter how the Board of Contract Appeals will view something, you have addressed every conceivable issue. First thing we said is we didn't do a termination for convenience. Second thing we said is, even if you don't agree that we didn't do a termination for convenience, here's why we still shouldn't pay $24,476. And I denied it, and they appealed this to the Board of Contract Appeals. And I thought it was a little unfair because since they were a nonprofit entity, they had a law firm that was doing the work for them pro bono. So they didn't have to pay anybody to take us to court. And we, of course, had to pay our expense for me and our attorney and the people in the program, etc., and they're getting this for free. So anyway, we ended up having the thing decided by the Board of Contract Appeals, and in its decision, the board agreed, number one, with the contention of Treatment and Learning Center that we had terminated for convenience, which was a shock to me, but that's how you learn things. What the board said was that a vendor has no right to terminate a state contract, which, yep, we're right. They have no right to terminate a state contract. Only the state has this right. So their logic was, if the vendor doesn't have the right to terminate, and the state's the only one that does have a right to terminate, and we just went through, there were 3 ways to terminate, well, process of elimination. It wasn't because of a lack of funding, and we didn't say it was for default. So if you subtract 2 from 3, you're left with 1. Ergo, we did a termination for convenience. That was the logic of Treatment and Learning Center, and that was logic that the Board of Contract Appeals upheld. Yes, you did, DHMH, do a termination for convenience. So now that we've established you terminated for convenience, now we'll see whether you owe the $24,000. Let's see. This is why they didn't have a termination for default. Let's see. So we agreed that there was no default, so that wasn't an issue. That left only termination for convenience, and under termination for convenience, a vendor may file a claim for incurred unamortized expenses. But whereas the Board of Contract Appeals agreed with TLC that DHMH had terminated the contract for convenience, it agreed with DHMH on the lack of merit of the several individual claims that totaled to $24,496. So although DHMH lost its primary contention that it had not terminated for convenience, it won because we ended up paying nothing of the $24,496. So again, that illustrates termination for convenience. You can file for claimed expenses, but filing it's one thing, getting it is another thing. And we have no exercise. Any questions of termination for convenience?
I think that it confuses me right there, because you weren't, you were doing what was right in the whole thing. I would have thought they would have come up with a 4th definition of termination then, because that was stupid. You did exactly what was right, and
So you only have 3 ways to terminate.
that's right.
So if you terminate, it's got to be one of those 3. And since it almost inevitably is not going to be a termination for lack of appropriation, you come down to the final 2. It's either convenience or default. And since it's usually hard to prove default, many times it comes down to convenience. So either you prepare to pay money, or you have language in there that you've negotiated that you'll call it a termination for convenience, but they don't have the right to come after incurred expenses, and then both parties sign and go away. If that's not the case, then maybe you're paying expenses if it's proven what the expenses are and they're reasonable. So with that, I think we take a break and come back in 15 minutes.